All right. Well, first things first, and that is, as you can probably see, I am back from vacation, back in my office. But unfortunately, my original office is still sitting at about a 90 to 95 degree Fahrenheit temperature, and that's just a little bit too hot for me. So we are still having unfortunate AC issues with my office. Even though I gave them a week to figure this all out when I went on vacation, still they're having some issues. But they do assure me and promise me that by tomorrow afternoon, my office will be sitting at a comfortable 68 degrees, and I'll be able to move right back in there. So for the time being, I am coming to you live from our conference room here at Radner Law Group, as well as Brother Counsel Studios. So that is the first order of business. The second order of business is that just today, Lawyer You Know dropped a podcast where I had a conversation with him. We had a great conversation. Great guy. We met for the first time. Hopefully, we're going to be doing a lot more shows together. We really hit it off well, I think. And we definitely had some off-the-air conversations also that I can't share with you. But hopefully, we will be having some more discussions about many more cases that we are both covering. So if you did not see that podcast, definitely go check that out. It's on Lawyer You Know's channel, and he just dropped it today, Monday. He's actually in the trial today. I'm supposed to be starting a trial September 8th. We'll see if that goes. But in the meantime, let's talk about Donna Adelson's trial. Donna Adelson's trial is actually supposed to start tomorrow. Tomorrow is jury selection in Donna Adelson's trial. And we, right here at Brother Counsel Studios, are going to be live streaming, God willing, the entire trial, beginning to end. Most likely, the first day is going to be either Friday or Monday, so keep your eyes peeled for that. As soon as they start with opening statements, we will go live with that first day of trial. So that is what we have coming up. But before the trial, there was an emergency motion that was filed by none other than Wendi Adelson. And today was the hearing where this motion was heard. So we are going to play for you this hearing that went on. I'm going to explain everything that happened. I think that there's a lot of nuances that some people may be missing. So that's why you come here. We're going to be picking up on everything, explaining everything. But first, before we play the hearing, let's get some background. Let's understand what this motion is all about. So then we'll be able to understand this hearing a lot better. So it started off with the motion. We'll pull up the motion right here. This is the motion that was filed by Wendi Adelson's counsel. So she has her own attorney that's looking out for her interests. And obviously, as all the Adelsons are getting rounded up, Wendi Adelson may not be feeling as comfortable anymore. And therefore, she's going to be definitely being very careful about what she's saying, what she's going to be testifying to. Definitely going to probably be much more careful now. But let's see what this motion is all about. So here we go. Non-party Wendi Adelson is the daughter of defendant Donna Adelson and is expected to be one of the first witnesses called by the state in Donna Adelson's trial. Both the state and the defendant issued trial subpoenas to Wendi Adelson. Okay, so now let's stop right there and explain that. Okay, both sides, obviously, both attorneys are representing both sides, the state and the defense, can issue subpoenas. You want a witness to come testify, then you have to issue the subpoena. Now, what happens if the state has somebody under subpoena? Well, do you as the defense need to subpoena that witness? And here the answer is not so simple. So depends. If you're going to need this person for your case in chief, when the defense wants to put on their case, if they want to, they don't have to, right? But if they want to, and they want to call this witness, well, then they do have to have that person under subpoena. Why? Well, when the state calls that witness, they can be asking them certain questions that will help the state's case. But the defense may choose, you know what? We don't want to ask all the questions of this witness at this time. We want to call this witness later, and in our case, to ask our questions that we want to ask this witness. So in that situation, when you both want this witness to testify about certain facts about your case, certain things that will be favorable to your case, so then you both put the same person under the subpoena. The state sends a subpoena and the defense sends a subpoena. And that's what happened with Wendi Adelson, because the defense is thinking, Donna Adelson, is that, I may need Wendi to testify about something that will be helpful for my case. She does have a lot of knowledge, after all, about the divorce, about the case, about Donna, right? They're very close. So there may be some issues that the state does not explore in their direct examination, which we do not want to bring up in their case. And we're going to wait for our case to call Wendi Adelson. So they both issued separate subpoenas. Okay, hope that's clear. Now let's move on. Donna Adelson is charged by indictment with first-degree murder, alleging she participated in a conspiracy to murder Dan Markell. Wendi Adelson's ex-husband on July 18th, 2014. Wow, over 11 years ago. Other alleged members of the conspiracy were charged and convicted, including Catherine Magbanua. In the Magbanua trial, both the state and the defendant subpoenaed Wendi Adelson to testify. So this was not the first time, meaning Donna Adelson's case is not the first time where both sides issued subpoenas to Wendi Adelson. It also happened in Katie Magbanua's trial. The state and the defendant both subpoenaed Wendi Adelson to testify. So what happened? Well, in that case, very, very similar to what happened in this case. In response, Wendi Adelson filed a motion like the instant motion to place a statement on the record and to quash the defense subpoena on May 13th, 2022. So seeking two things. Wendi Adelson seeking two things. Number one, to place a statement on the record. What does that mean? Well, the record is just simply open court. You're in court. Anything that you say goes on the record that is transcribed about anything that's going on in court. So Wendi Adelson wants to put something on the record. Well, I wonder what it is that she wants to put on the record. And of course, the motion will talk about what she wants to put on the record. So number one, we say, Your Honor, Wendi Adelson is going to be called to testify. Before she does, we want to place something on the record. Most likely not in front of the jury. Also, to quash the defense's subpoena. So the defense issued a subpoena. So just like in Katie Magbanua's trial, Wendi Adelson moved to quash the subpoena, so that she does not have to comply with the subpoena. Well, similarly, that is what's going on in this case. Donna Adelson, their team, subpoenaed Wendi Adelson to testify. Now Wendi Adelson is moving to quash the subpoena. Now it could be someone like Wendi, the person who's being subpoenaed, could move to quash it. And also the attorney on the other side could also move to quash it. Anyone who has an interest in this case could move to quash it. Sometimes you do find that the attorneys, even though they're not specifically representing the person who is subpoenaed, but still they'll move to quash that subpoena. Okay, but in this case, Wendi Adelson is the one who's moving to quash the subpoena. Thus, the two trial subpoenas by each party in this case present the same issue the court dealt with in a previous trial. The state subpoena affords Wendi Adelson use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment rights, while the defense subpoena provides no such protections. What does that mean? Okay, well, what this means is very simple. Anybody can be forced to testify. Let's start from the beginning. Anyone, right, who is subpoenaed by the state or the defense. The defense has a Sixth Amendment right, and the state also has subpoena power to subpoena someone to testify. So both sides have the power to force somebody to testify. Now, what happens if that person's testimony is going to be incriminating? Well, that person then has a Fifth Amendment right, right? We all have Fifth Amendment rights to not testify against ourselves. We cannot be forced to incriminate ourselves. That's our Fifth Amendment right. We have the right to remain silent. Okay. So now what are we going to do with this problem? We have a Sixth Amendment right by the defense, and also the state has a right to subpoena people to testify. And that person does not want to testify because it's going to incriminate them. They have a Fifth Amendment right. So what trumps? You have a Sixth Amendment right. You have the state's right. You have this person's Fifth Amendment right. And they're very obviously in conflict. This person wants to remain silent, and the state wants them to testify against, let's say in this case, Donna Adelson. So what should they do in this type of situation? Well, that is where a certain case called Castigar, which is actually, we did a video on this like 2 years ago, something like that, where Castigar is a case which explains what to do with this type of conundrum. And basically what Castigar says is that the state can still compel that person to testify, but the state has to give that person immunity, which means, okay, you have a Fifth Amendment right to remain silent. All that really means is that you can't be forced to incriminate yourself. Well, we will work out a deal with you, since we are the state, we're the government, that we will not press charges on you from anything that you say. Anything that you say will be protected. It's called use and derivative use. So use means anything that you say. You actually say. If you say, yes, I was right there when the murder was committed, I was part of it, I was behind it, I was an accomplice of it, whatever. You could say that, and then the state cannot use that against you. Derivative use is where you say something, and then the state will go investigate on what you said, and then a few steps down the line, they'll figure out something that's incriminating against you, but they only got that information. They started this investigation through your statements that you gave in court. So that's called derivative use. You're also protected from any incrimination, anything that's incriminating from the state learning from your statements, different things that could be incriminating to you. Okay, so there's use and derivative use immunity, which the state can promise you in exchange for you testifying. So that way your Fifth Amendment rights are still protected and the state gets to use you to compel you to testify against the defendant. Now, that's all as the state is concerned. The state actually has the power, right? They have, after everything, they have the power to prosecute someone or not prosecute someone. So they can promise someone, okay, we are going to give you immunity to anything that you say. But what about the defense? Can the defense grant any immunity? What about that? So here is where the defense cannot, right? What am I? I'm just a defense attorney. I can't prosecute people. So if the defense wants to subpoena someone, and in fact, they have a Sixth Amendment right to. You have a Sixth Amendment right to force people to testify on your behalf. But here, that person has a Fifth Amendment right that he doesn't want to say anything. And the defense cannot promise him immunity. In that situation, when it's coming from the defense, then the Fifth Amendment trumps the Sixth Amendment. So when it comes to Donna Adelson, since she cannot promise Wendi any sort of immunity or use derivative use or use immunity, well, then she has no power to force Wendi to testify. And that's exactly what this argument is. So again, thus, the two trial subpoenas by each party in this case present the same issue to the court dealt with in a previous trial. The state subpoena affords Wendi Adelson use and derivative use immunity for her testimony in an instance where she would otherwise invoke her Fifth Amendment rights, while the defense subpoena provides no such protections. In the McBanoa trial, the court quashed the defense subpoena and granted Wendi Adelson's attorney an opportunity to place a statement on the record. So this is exactly what happened in Kane McBanoa's trial. We filed the same exact motion. This is, again, Wendi Adelson's attorney talking. We filed the same exact motion, and the judge, in that case, I think his name is Judge Wheeler, Judge Wheeler said, you're right, we are going to quash the subpoena by the defense, which means that Wendi does not have to come testify as part of the defense's case in chief. And we are also going to allow Wendi to, through her attorney, obviously, to place a statement on the record. So what do you think they're asking in this case? Well, the same way that they allowed that, that's what Judge Wheeler allowed in Kane McBanoa's trial. Well, then we should try that. We should also, in this case, the Judge Everett, should also rule the same way. That's essentially what this motion is about. Wendi Adelson will testify pursuant to the state subpoena, but without such a subpoena, she would invoke her rights under the Fifth Amendment to the United States Constitution and etc. As a result, Wendi Adelson requests that once the state calls her as a witness, her counsel should be allowed to place on the record a statement outside the presence of the jury that, and here's the statement, number one, and you probably will not be hearing this in the trial, I assume. They may cut off the cameras at this point, but this is what the statement is going to be. That number one, Wendi Adelson intends to invoke her Fifth Amendment and Section 9 rights. And two, Wendi Adelson's testimony is entitled to use and derivative use immunity. And three, use and derivative use immunity extends to any testimony given during Donna Adelson's cross-examination of Wendi Adelson. Okay, so now let's explain that. The way immunity works is that it's not just that the prosecution, since they're the ones, after all, the state has the power to give somebody, grant someone immunity or use immunity or derivative use immunity. They have the power to grant this immunity. So then the state can say, you know what, that only applies to our questions because, we want this person to testify against the defendant. So we will grant you that immunity as long as it relates to our questions. But when it comes to the defense, they want to ask you cross-examination questions based on our questions. No, we're not granting any immunity. Well, no, it doesn't work that way. That's way too unfair for the defense, right? So in this situation, if the state wants to grant a level of immunity, use and derivative use immunity, and by the way, there is a stronger level of immunity, transactional immunity, but we don't have to get into that for this video. So if the state wants to grant that immunity to Wendi Adelson, it also has to include any cross-examination that has to do with the direct examination, okay? Because that's just patently unfair. You can't just have immunity for the state's questioning, and now the defense is stuck not being able to ask any questions. So that's too unfair to the defendant. So it also extends to any testimony given during cross-examination. To ensure full protection of Wendi Adelson's rights, she respectfully requests the opportunity to state on the record her entitlement to these important constitutional and statutory rights. Now, really, there's not really a need for her to make any statements in court, right? These are all laws that are in the law, in Florida, in the federal good system. I mean, these are laws. So these are direct quotes from cases. But to be abundantly clear, to use abundance of caution, we want to make a record before she testifies. Okay, who's going to have any problem with dotting your I's and crossing your T's? Go ahead, you can make that record. So that's essentially what they're asking for. Let's just make the record of what the law essentially is. Okay, now let's move on a little bit more. Although Donna Adelson will have a full and fair opportunity to cross-examine Wendi Adelson at trial, and despite knowing that she would otherwise assert her Fifth Amendment rights, Donna Adelson's counsel issued the defense subpoenas. Unlike the state subpoena, the defense subpoena confers no such immunity, and therefore they're going to ask for him to quash it. Simply put, the defense has no ability to confer immunity upon a witness under Florida Statute 914, etc., even where the witness is likely to provide exculpatory and reliable evidence. It doesn't matter what type of great evidence that person has to testify about, but if the defense, if they are nervous that it's going to incriminate themselves, then, and the defense has no way of conferring immunity on them, well, then they cannot be forced to testify. Florida law is equally clear that it would be improper for a party to call a witness for that witness to invoke her rights before the jury. Now, here's the next part about this that you have to understand before we get to the hearing. Once you understand all of this that I'm explaining, the hearing is going to make a lot more sense. So now, Florida law also says, what about calling somebody in front of the jury, asking them a question, and then that person has to, in front of the jury, invoke their Fifth Amendment rights? What about that? Can the defense do that? Why not? Why can't the defense do that? Defense will call Wendi Adelson. Okay, we have the power to subpoena. We're going to subpoena you to the stand in front of the jury. We're going to ask you a question, and then you'll say, you take the fifth. Okay, no problem. No problem. Therefore, your Fifth Amendment rights are protected, and there's no problem. What's the issue with that? Well, here the case law says, no, you can't do that either. You can't do that. You can't call somebody to the stand just so that in front of the jury, they can plead the fifth, and then, even if you're not, as a defense, able to use that at any sort of argument in closing arguments, but still, the jury got the point that there's a person here who's trying to hide information because they're nervous it's going to incriminate them, and maybe that has something to do with this case, and, the jury can start thinking about reasonable doubt. So that's not fair either. So that is another part about this, that we are not going to allow Wendi Adelson just to take the stand so that she can invoke her Fifth Amendment rights in front of the jury. All right, and that's essentially what the motion is. Okay, now that we understand the motion, now we basically understand what's going on here, now we're going to play for you the hearing. It's a very short hearing, and actually something interesting in terms of argument comes up. So it's a short hearing. We're going to play it, and then I'll try to pause it a little bit when something interesting actually happens and needs a little bit of an explanation. So here we go. Courtesy of Court TV right there. And let's go. Let me just see what the speed is here. 1.25, which is good for you. If you can listen to me, then this is probably good enough also.
Good afternoon. I have reviewed your...
And I know that there's some sort of little bit of an issue with the microphone there. Hopefully it won't be there by the trial. But if you're going to hear, it may not be as clear. That has nothing to do with me. I can't control it. That has to do with the microphone in front of the people speaking. But it's pretty clear, so you'll be able to hear it.
Mr. Morrow, concerning the defense's subpoena, as far as placing a statement on the record, I don't know if any of the parties have a position concerning you placing a statement on the record, but similar to the other trials in this matter, I do not have an issue if you do so prior to the testimony of your client. As to the placing the statement on the record, does the state have a position?
No objection, Your Honor.
Does the defense have a position?
No position, Your Honor.
Okay, so the first thing is the easiest part. Sometimes the judge always wants to take care of the low-hanging fruit first. Would anybody here have an objection if Wendi Adelson's attorney puts something on the record? Like, no, why would anybody have an issue with that? So, yeah, we just have to take care of that. So the state says, yeah, we have no problem with that. And the defense says, yes, we have no problem with that either.
Concerning placing a statement on the record, Mr. Morrow, you will be permitted to do so, or another member of your firm, before your client testifies. As to the motion to quash the defense subpoena, does the state have a position?
No, Your Honor, no position.
Okay, so he asks the state, do you have a position? Do you want to oppose the motion that was filed by Wendi Adelson's attorney? Do you have any position about that? So the state says, no, we have no position about that at all. No, we have no position. You can, whatever you want to do, Judge. You want to quash the subpoena? You don't want to quash it? We don't care. So the state has no position about this anyway. They don't. So let's see what the defense position is.
Does the defense have a position?
Yes, Judge.
Go ahead.
What a surprise. Obviously, the defense is going to have a problem with this because they issued the subpoena. They want Wendi under subpoena in case they feel they need to ask her some questions, and therefore they do not want the subpoena quashed. So they're going to oppose this, and let's see what the argument is.
May I stay here?
You may.
Judge, the issue here and the concern that we have on behalf of Mrs. Adelson is there have been 2 prior rulings in the homicide of Mr. Markell. One came from Judge Hankinson, and then another one came from Judge Wheeler. What Judge Hankinson ruled is that the immunity conferred by the state subpoena extended to cross-examination, and we believe that's an accurate statement of the law. However, Judge Wheeler limited cross-examination to only what the state brings forth on direct.
So what she's trying to do is she's trying to say that there's a difference in opinion about what exactly we are limited to on cross-examination. So now you all understand at this point that the immunity extends to cross-examination, but how much of cross-examination? Is it everything in cross-examination, or is it only limited to the specific areas in which the prosecution went into? But any additional areas would the immunity be granted as well? So they're going to want the immunity granted as much as possible, so that the defense can cross-examine on as much as possible. Now, does it really make a difference? I don't think so. I think that she's trying to create an argument here when one doesn't really exist, which is what the judge is going to eventually rule. But that's the argument.
Premature at this point, Judge. We have her under subpoena, and we may want to elicit testimony from her.
Well, before we get there on that point, when she's called as a state witness and she is cross-examined, she can be cross-examined on all matters raised by the direct and on matters of bias or impeachment or motive to lie. All matters that she can be cross-examined on pursuant to the rules of evidence extend under that state subpoena.
I understand that, Judge, but our issue is, suppose that she's one of the first witnesses to testify, and suppose after she testifies, other issues come up that we know if we called her, she could rebut what has been said. It's not necessarily, it would be something that she would need to invoke her rights. It could be a very simple issue, and we would need her testimony. So
she's really moving on to a different argument. You see how this argument started off one way, the judge kind of shot it down, and then she kind of moved on to a different reason why the motion to quash should be denied, meaning that Wendi Adelson should still be able, the defense should still be able to call Wendi Adelson, and she should remain under the defense's subpoena. The first issue, the judge basically said, no, there's rule of evidence very clearly what you're allowed to cross-examine. Everything that you are allowed to cross-examine under the rules will be protected. She will have immunity for. So you're trying to make a difference here between the 2 different judges? No, that has nothing to do with this. Everything that is allowed under the rules to be cross-examined on based on what the state's direct examination of Wendi Adelson is, she will be protected. So don't worry about that. So then if that's the case, well, then what do you need to call her for? Right? That's for your cross-examination based on the state's subpoena, right? The first part of our argument was the state's going to call Wendi Adelson under their subpoena, and now we get to cross-examine, but we need to be able to cross-examine on everything that we're able to, and therefore we have to know the extent of what the immunity is granted for. And there the judge said, well, everything that you are allowed to cross-examine under the rules. Okay, so that's clear. Now what else? Why else would you as the defense need her under your subpoena? You cannot grant her any sort of immunity. So here is where she's, I know her first name is Jackie. I forgot her last name and I apologize. But this is the defense attorney arguing that, well, we may need to ask her questions that the answers will not be incriminating. Maybe we just want to ask her some questions about, how Wendi was when she was a baby. Things that are not incriminating at all. So we want her under the subpoena to be able to ask her those type of questions.
we go through the trial to see what happens. It's impossible for us to say, yes, just cross-examining her on bias and credibility and whatever the state has asked about sounds good in the state's case until we hear further testimony and some issue arises.
And also, it would be if, let's say, somebody else testifies in the state's case later after Wendi testifies, and then we want to call her to rebut that, which is not incriminating. We want to be able that opportunity or that ability to be able to do that in our case.
Allow Mr. Lawyer to make his argument, but the crux of his motion is you cannot offer this witness any protection as it relates to you calling her in your case in chief. What is your response to the written argument on that matter?
Yes, Your Honor.
Hold on, Mr. Lawyer. I'm going to allow Ms. Fulford.
I'm sorry, I thought you were asking me. I'm sorry.
Okay, I think it's Ms. Fulford. So Jackie Fulford is the defense attorney, one of them.
You can make your argument in just a moment.
Yeah, so the issue as to immunity, we cannot confer immunity to her, Judge. We agree with that. We can't. But there may be other issues where she can testify to something that she's not taking a chance, if you will, that she's going to say something that could be used against her in the future. There could be other matters that are raised in the trial that we simply want to get testimony from her as. She is the daughter of our client.
From the perspective of your client.
So again, she's saying, you're right, we cannot grant her immunity. Responding to the judge, you're right, we cannot grant her immunity, but we still may have questions that are not incriminating for her to answer. And that can help our case.
Fine, I certainly understand the argument you're making, Mr. Morrow. You may argue.
Yes, Your Honor, this issue was addressed by Judge Wheeler in the second McBanwell trial.
And this is where it's a little hard to hear. I think he's on Zoom, which is why it's probably hard to hear. But he's saying that this issue was addressed by Judge Wheeler in the second trial of Katie McBanwell. Remember, there's 2 trials with her. The first one was a mistrial, so hung jury. And the second one, they got the conviction. So the second one was Judge Wheeler.
It was also decided upon by the first DCA in July 2025, when the DCA ruled that the procedure used by Judge Wheeler was entirely correct, and the subpoena in that case was quashed.
So here, what his argument is that this exact issue came up, and in fact, it went up on appeal. So this is not just a issue that was dealt with at the trial level. This was an issue that was dealt with at the appeal level. They appealed this specific issue. And the Court of Appeals just recently came out in July of 2025, just last month, came out with an opinion explaining that what Judge Wheeler did in Katie McBanwell's second trial, which is this exact issue, was perfect. So if the Court of Appeals is saying what Judge Wheeler did is perfect in McBanwell's trial, well, guess what? You should probably follow that in this trial.
It's the same issue that the defense raised, where they wanted to cross-examine my client pursuant to a defense subpoena, which conferred no immunity at all on Ms. Adelson. I indicated to the court then, as I will now, that Ms. Adelson will assert her Fifth Amendment rights with respect to any relevant question asked by the defense. So the only result of the defense procedure would be to have the client's daughter take the stand and invoke the Fifth Amendment in front of the jury. And that the court decided by Judge Wheeler that would be inappropriate. And we would ask the court now.
And that's where he talks about his second argument is that, so therefore, if they cannot grant her immunity, well, then the only reason of calling her in front of the jury is so that she'll invoke the Fifth Amendment in front of the jury, which is also inappropriate, as we spoke about earlier in the video.
Follow the same procedure as Judge Wheeler and follow the same procedure that was upheld by the first DCA just 1 month ago.
Does the defense have any remaining argument on this matter?
Your Honor, respectfully, the issue that was ruled on or concerning the subpoena, quashing the subpoena, Ms. McBanwell did not make that argument below. She did not join the state's motion. So the first DCA did not rule that Judge Wheeler followed the proper procedure. My understanding is that the first DCA held that she had not preserved the argument.
Okay, now what does that mean? This probably flew over a lot of people's heads. His argument here is that what the Wendi Adelson's argument was, her attorney's argument, was that this specific issue was litigated at the Court of Appeals level. And at the Court of Appeals, they held that you should quash the subpoena. That is exactly what his argument was, Wendi Adelson's attorney. Now, here's Joshua Zuckerman, and he's another defense attorney for Donna Adelson. And he's saying, actually, it was not argued appropriately at the Court of Appeals level because Katie McBanwell did not preserve that argument. You hear that? When it gets to the Court of Appeal level, there's 2 ways that they can deal with an issue. They can deal with an issue saying, based on the merits of the issue, they can analyze it under the case law and say, this is our analysis and this is what our ruling is. Or they can say some other technical issues with the appeal. Like, for example, you did not preserve this at the trial level. You didn't make it a timely objection, or you didn't make a record about it. And if you didn't do that, we're not talking about it. So we're going to uphold the conviction. We're going to affirm the conviction, but not because we have some great analysis using the case law in Florida. It's because of a technical problem, a technicality. You forgot to preserve this issue, so therefore we're not going to weigh in on it. So what Joshua Zuckerman is saying here is that, no, this issue was actually not litigated at the Court of Appeals level, and it was not analyzed appropriately, and therefore it's not binding on this court. Now, that's a very interesting argument, and you can find out the answer pretty simply. All you have to do is pull the case, which guess what we do on this channel? That's exactly what we do. So we're going to pull the case in just one moment, but I just wanted to point it out that this is actually a very important argument, whether there's some binding case law about this issue.
And if I could add one thing further,
We don't have tag team motions. Who's going to finish the argument?
Just a moment, Your Honor.
It's funny because now they're both trying to argue. And actually, if you remember that Jackie Fulford was the one who started the argument, and Joshua took over the argument, and now the judge saying, well, you can't tag team and let her finish the argument, even though she was the one who started it. So it's a little mixed up here, but anyway, just listen.
Your Honor, factually, we're in a vastly different circumstance. Our client certainly has information, knows information about her daughter that Ms. McManus would not have ever been able to know. And so it's our position that it's premature. The Fifth Amendment question, the courts have ruled should be done on a question-by-question basis.
So now he's really coming back to what Jackie's first argument was, and that was Katie McManus didn't have any sort of relationship with Wendi Adelson, not a close one anyway. And there's no reason to call her unless you're going to be asking some questions that she could give incriminating answers to. But when it comes to Donna Adelson and Wendi Adelson's relationship, there's obviously much more of a difference there. It's going to be a very important difference, and therefore Wendi should still be able to testify or still remain under subpoena by the defense in case there's other issues that we want to ask them. Some simply harmless issues that we want to ask her.
So your expectation is for me to ask the question, she will make some sort of signal, I'm invoking, the jury is to be removed, and then we do this for the entire defense direct?
No.
So there he's saying, well, it should be on a question-by-question basis. That was the end of his argument there, that we should do this at a question-by-question. We'll call her, in our case, and we'll ask her a question. And if it's just a simple, harmless question about, I don't know, what they had for dinner one night, then she'll be able to answer. And as soon as this gets into some area which could be incriminating, then she'll make a signal or something. That's what the judge is suggesting. So then she's going to make some sort of signal, and then we're going to send the jury out, and then she's going to invoke her Fifth Amendment rights. I mean, that's not going to be a very efficient trial. So here, Josh is going to say, no, that I have a much better idea.
Your Honor, what I would suggest is that if we get into this posture, and absolutely cross-examination may be sufficient, but if we get into the posture of needing additional, I would suggest that potentially proffering the questions, and then she and her counsel can advise the court if she intends to invoke her privilege at that time.
Mr. Lawyer, last.
So he's saying we can submit the questions before, and we can do it all before the jury, but before the jury comes out. We don't have to do this in front of the jury. Well, and you could do this. It's called a proffer, right? You could proffer. You can say, Your Honor, we can just do this not in front of the jury. We'll have Wendi come. She'll take the stand. We'll ask her a bunch of questions. You'll decide whether these are incriminating or not, and then we'll have our answer right then. That's a reasonable suggestion, by the way.
And then I will rule.
Yes, Your Honor, the statement by counsel was patently incorrect and false. This issue was raised by Ms. Gawals in the McManus.
So the first thing that he's arguing, now this is Wendi Adelson's attorney talking now, the first thing he's saying is that, no, Mr. Zuckerman, you're wrong. This was an issue that was in front of the court that was decided on the merits. So this should be a very simple answer. All you got to do is pull the opinion. One of them is saying the truth. One of them isn't. We'll see in a moment what happened there. And maybe there's just a confusion there. But here the defense attorney is saying, no, he's absolutely wrong about that. It wasn't because they failed to bring up preserve this issue. It was actually ruled upon based on the merits. So we'll see about that in a minute because I have the opinion pulled up, but let's just finish the hearing.
On our trial, she preserved the issue. She made the same arguments that these defense lawyers are making now. It was wholly rejected by Judge Wheeler and wholly rejected by the first DCA. And we respectfully request that Your Honor follow that ruling here. There's simply no question that the defense could ask that is relevant to this matter that Ms. Adelson, my client, would answer. She's invoking her Fifth Amendment.
Right. Having reviewed the applicable authority on this issue and also reviewed the prior transcripts on this matter that were also ruled on by Judge Wheeler concerning this same subject, I am going to adopt a similar ruling. The defense cannot give the witness immunity as it relates to any matters in which she would testify under and could properly invoke the Fifth Amendment privilege. No witness can be called to the stand simply to invoke the Fifth Amendment, as there would be no basis for this witness to take the stand and give testimony on a relevant matter and also could not affect her ability to also endanger her own Fifth Amendment right. I am going to grant the relief that is requested. If we need to revisit this issue for any purpose where the defense believes there is a lie.
Okay, so basically he's ruling exactly how Judge Wheeler did. And he's saying that that we are going to quash the subpoena. Sorry about that. We're going to quash the subpoena, and that's the end of it. You know, you'll be able to give the statement before she teaches, before she takes the stand, and basically the same ruling that Judge Wheeler did. But I want to bring up this opinion because I think it's interesting about what we were just talking about. Did the Court of Appeals talk about this or not? So let's bring up the opinion right here. This is the opinion that just came out. You see July 2nd, 2025. So this is really, really fresh. And it has to do with Katie McBanoa's second trial. Following a second jury trial, appellant Catherine McBanoa appeals her convictions for first-degree murder, conspiracy to commit murder, and solicitation to commit murder arising from her involvement in the shooting death of Florida State University law professor Daniel Markel in July 2014. For the reasons below, we affirm McBanoa's convictions. So they go through a number of the different issues that came up, but this is exactly where it's addressed, what they're talking about. And the answer to this is that they're both kind of right here. Okay, you got to be careful with these opinions, and we're going to see exactly what happened here. Third, McBanoa argues that the trial court erred in not granting the state's motion in limine to prohibit McBanoa from calling any witness, including Adelson, for the purpose of talking about Wendi Adelson, for the purpose of the witness invoking the Fifth Amendment. The state requested that certain procedures be followed, including that the trial court make a pretrial ruling on what questions McBanoa could ask Adelson as a defense witness. So there was a motion that was filed by the state. So in McBanoa's case, this was a state's motion in limine, and the trial court denied it, did not grant it. And now the defense, McBanoa, wants to appeal that order. So here, and I have this in a different color here because it's important, because McBanoa did not join in the state's motion, she cannot now complain that the trial court erred in not granting the motion. Well, did you join in the motion, Katie McBanoa? No, you did not. Well, if you did not join in the motion, then you cannot complain now, because the general rule on appeal to review proceedings of an inferior court is that a party to the cause may appeal only from a decision in some respect adverse to him. So it has to be your motion. And you can now argue that that was a decision that was adverse to you. But if it was not your motion, it was the state's motion, you didn't join the motion, well then, can't argue that it was adverse to you. But here's where it gets, so the first part actually seems very similar to what Joshua Zuckerman was arguing. This is because they failed to preserve it, meaning they did not join in the motion. But here's where it gets interesting, because the court continues and says, additionally, meaning even if we were to put that argument aside, that technicality aside, additionally, during the second trial, after Adelson's counsel advised that Adelson would unequivocally invoke her Fifth Amendment right to any question asked of her, unless she was under a state subpoena, the trial court properly ruled that she could not be called as a defense witness. So here is where the court is actually adding, saying, even though we have a technicality to get out of this, but still, we are going to still say that since exactly what just happened in front of the court, in front of our eyes, that she was going to invoke her Fifth Amendment right, so the trial court properly ruled that she could not be called as a defense witness. So technically, they're both right, but there is a ruling here on the merits of this. That's where the additionally comes into. All right? Well, that's where that ends up. So Wendi Adelson will take the stand, obviously, as we know. Seems like she's going to be one of the first witnesses, and the defense will be able to cross-examine her based on what the state asks her, and whatever they're allowed to cross-examine will be covered under the use and derivative use immunity agreement. But she is going to be released from the defense's subpoena, and if there's some other reason that they have to bring it up with the judge later on, they can try to bring it up with the judge, but nothing's probably going to change about that order. So that is what happened today in this emergency motion, and now it's all clear. And now we are all ready for Donna Adelson's trial to begin. It's starting tomorrow with jury selection. We're not going to be able to see what's going on in court. Maybe we'll get some reports from people that are in the courtroom, but it seems that the opening statement should begin Friday or Monday. If it happens Thursday, that will surprise everybody. I mean, that will be the fastest jury selection that I can imagine, because the first day they're really just going to be going through the pre-trial publicity part of the jury questions and seeing, who's ever heard about this case before. And again, it's been going on for 10 years, so it could be a lot of people heard about it. So they're going to spend basically an entire day on that. And then Wednesday, I think they're going to start already beginning with the actual voir dire of the jury on Wednesday, and then may take 2 days to actually sit a jury. So that's going to be Wednesday, Thursday, and then most likely it's going to be either Friday or maybe even through Friday. Sometimes these jury selections take a long time, but they're hoping that they're going to be able to finish it at least either Friday or Monday. So keep your eyes peeled. We do plan on live streaming the trial. Definitely join us here at Brother Counsel Studios for live real-time analysis of the trial. And of course, we will also be trying our best to give the recaps after each day of trial. In case you cannot join us for the entire day of trial, we should be able to recap everything that happened each day in trial. So we're looking forward. Finally, this trial is looks like it's going to happen. And you should join us while we watch this trial together. So we'll see you all back here then. So that's going to be it for now. If you haven't yet, please subscribe and like, and we will see you next time.